A very good evening and hello, albeit to Mr. Wong Hua Siong and to my fellow colleagues present tonight. My name is Himatarshini Kumaran and together with me, my group members, Siti Nur Aimi, Nur Atira Nabiha and Tarani Gunasekran. It is our pleasure to welcome Mr. Wong Hua Siong here as our speaker for tonight's event. Your presence is a very big honor to us. First of all, how would you like to address throughout this event, sir?
You can address me as Wong.
Okay.
Mm.
All right. Thank you, Mr. Wong. How are you doing tonight, Mr. Wong?
I'm fine, thank you. How about you all? Hope that
Yeah,
everyone is fine too.
yeah, I'm fine. Okay. We hope you're doing very well at your current residence. As for
Mm.
enlightenment, I would like to explain a little bit about our event tonight. This event is a pre-recorded event whereby we will record tonight's talk and then publish it to the public tomorrow via our social media platform. This event was held in pursuance of an assignment of one of our law subjects, which is GLUP 4233, Alternative Dispute Resolution or ADR, and it is a part of our E-Service Learning E-Sulam. Before we begin, I would like to share a short introduction of our speaker today, Mr. Wong Hua Siong. Mr. Wong completed his law degree with honours at Universiti of Malaya in 2005 and subsequently graduated with a Master of Laws from the same university in 2009. Prior to joining Multimedia University, Mr. Wong was an advocate and solicitor. Mr. Wong has also completed his postgraduate diploma in Sharia law and legal practice from International Islamic University Malaysia and subsequently graduated with the Master of Business Administration from the same university in 2019. Mr. Wong's research interests are in the area of conveyancing practice, business and commercial laws, including banking law, alternative dispute resolution in mediation, law of insolvency and land law. He is also a certified mediator of Bar Council, Malaysian Mediation Centre, MMC. Currently, he is a PhD student at Universiti Utara Malaysia in the School of Law. We would like to thank Mr. Wong for accepting our invitation to speak about tonight's topic, an issue that is going to be very beneficial for married couples in the event of domestic violence. Our topic for tonight is domestic violence. Can it be solved through mediation? As a short introduction, mediation is a form of alternative dispute resolution by way of involving an impartial third party to facilitate dispute between parties to arrive at an amicable settlement. Therefore, it is our mission tonight to discover the availability of mediation to overcome disputes of domestic violence and whether there are other methods of alternative dispute resolution that could resolve such disputes. So for tonight, Mr. Wong as the speaker will give us a presentation on the topic. After that, we will move on to the question and answer session. Before ending the session, we will have a photography session. Thus, without further ado, we would like to invite Mr. Wong Hua Siong to take the stage.
Okay, thank you very much for the chair ladies for your introductions. Good evening, everyone. Okay, my name is Wong. So it's my honor to reach to this event to be one of the speakers to share with you of my experience about the mediations. So this evening, our topic of this discussion will be on domestic violence. Can it be settled through mediations? Okay, just let me to share my screens. Okay. I hope that you all can view my screens.
Yes,
okay.
sir. We can.
Yeah. Okay. First of all, let you see this picture first. So what do you think about these pictures? So generally, we will see if let's say there is a couples, they are arguing of the family matters, or even though we have between our friends and friends, we will have the arguments. So even though the corporate partners or in the business events. So I think every one of us are very familiar, is very familiar with this sentence. We will say, see you in court. So what does it mean? It means we cannot solve our dispute and we would like to bring it to the court. Okay, but however, the question that we have to ask ourselves is it all the disputes can be settled through the court resolutions? Whether the outcome of these court decisions will satisfy both parties or not. So that is the ones that we have the we arrive this alternative dispute resolution, or we call it ADRs, to actually assist the court to dispute the settle the dispute. However, bear in mind, this ADR, it does not represent as one of the mechanisms to substitute the court functions. So it's just as one of the mechanisms to facilitate and rather not to substitute. So in ADR, basically we have these 5 categories, i.e. mediations, conciliations, arbitrations, adjudications, and negotiations. So this process actually different from each others, but they are philosophically linked as they constitute as a main process of this ADRs. Okay, now as I said earlier, it's not intended to substitute the court systems, but it's an alternative to these court systems. Now, as an effective dispute resolution mechanisms, especially in these mediations and arbitrations, it helps to reduce the backlog of the cases which are the result of these litigations. So, because as we know, the court system is very costly, time-consuming, and even though emotionally disrupting. So the next ones, basically all the civil dispute can be resolved through the process of mediation. So it allows the disputing parties to discuss and develop the creative solutions to the dispute that generally not possible in the court or during the formal hearing and appeals. Now, what is mediation? Basically, before we go into it, mediation basically is one of the mechanisms in these ADRs, which they require a third parties, or we call it mediators, to help the two parties negotiate the voluntary solutions to the dispute. Now, of course, these mediators, they have a certain criteria. He cannot become a suggest resolutions from this dispute. The resolution of the dispute must come from the disputants. So his role is only to assist the parties to reach the agreements. And the mediation can help to clear the backlog of the cases. Now, eventually, court-annexed mediations has become the mandatory in the court now. So if we know, as required in the rules of courts, like certain cases, civil cases, before we go to the court for the trial, we have to go through the mediation process first. Okay, now then we come back to the relevant keywords here. What is domestic violence? Okay, now domestic violence happens when a man or woman regularly hurt his or her spouse physically or verbally, such as beats or mentally tortures the others. Now, this domestic violence can happens not only to women, it could be happen to men as well. So because always we were here, okay, the victims of this domestic violence could be women, but in fact, men could be the victim as well. Okay, now in the Article 1 of the United Nations Declarations on the Eliminations of the Violence Against Women, proclaimed by the United Nations General Assembly in his resolution 48/104 of the December 1993, defines violence against women as any actions of gender-based violence that result or likely to be result in physical, sexual, or even those psychological harms or suffering to women, including the threat of such acts, coercions, or arbitrary deprivations of liberty, whether occurring in public or private life. So, in fact, actually, there is a protection against this violence is guaranteed under the Article 3, Clause sub H of these United Nations declarations on the eliminations of the violence against women, whereby it affirms the women's equal rights to the enjoyment of the various rights, including rights from this torture or cruel or inhuman treatments. Now, according to this Women's Act Organization report, and this author Rostina, they believe that the men are superior and women are subordinate to the men, which lead the genders discrimination and subsequently to the power imbalance between men and women. But this belief, even though now it still exists in our culture and tradition, even though whether it's Chinese or Indian or Malay society in Malaysia. Okay, now for examples, they say a husband is acknowledged to have absolute authority over his wife. Now, whether this statement is true or not in our current station is questionable, because this could be maybe 10 or 20 years or 30 years ago. It could be correct. But nowadays, I think we have to revisit of these statements, whether husband is to have absolute authority towards his wife or not. Okay, so then of course they say because of this because of these examples, they say it will lead to the discrimination in the form of devaluing the women's and his contributions. That means they don't recognize or devaluate the women's contributions. In fact, actually, they have equal rights and equal contributions. And of course, because of this devalues of the women's contribution, which eventually will lead to the violence, whether it's physical or psychological. Now, of course, this is some of the examples of the physical violence, and including physical and sexual. And of course, it will include the powers and controls. Okay, then these are some of the domestic violence cases in Malaysia, which I found in this website. So unfortunately, I only managed to get until 2018. They published until 2018. So we will see about 20 years ago, average is just about 2,000 to 3,000 plus. But recently, it increased more than 5,000 cases per year. So of course, then the question to us is, since the cases are increasing from year to year, whether in our society, whether we have taken any initiative or any steps to reduce or to find out how do we resolve this domestic violence. Of course, this will involve of the institution, family institutions. Okay, now let us look at the law related to the domestic violence. In Malaysia, we have this Domestic Violence Act 1994. Now, okay, so what does it amount to this Act of Domestic Violence? In sections 2, of course, there could be various scenario here. For example, they say you could put the victims in the fear of physical injury. I think this is very obvious. They use physical injuries. Then, of course, they have the threat force or threat to engage in any conduct or acts or sexual or otherwise from the victim has a right to abstain. And subsequently, of course, these are some of the new insertions in this reasoning. They say destruction of the damage to the property which intend to cause or likely to cause the distress or annoyance to the victims, and misappropriating the victim's property which causes the victim to suffer distress and due to financial losses. Now, then of course these are some of the examples which define what is the act of domestic violence. Okay, then they say further to constitute the domestic violence under this Domestic Violence Act 1994. Okay, so it will, the above acts, which is domestic violence, as have been committed by the offender, whether by himself or through the third parties, against spouse and the former spouse, children's, incapacitated adults, or any other members of the families. And so this could be, they say, could be possible victims of this domestic violence. That means it's not only between husband and wife, so it could be extended to this, how to say, the family members. But however, bear in mind, this Domestic Violence Act 1994 only expressly to spouse that does not apply to the unmarried couples. Okay, so if let's say boyfriend, girlfriends, so this act may not be relevant to them. Okay, now in Malaysia actually have ratified these conventions on the eliminations of all forms of discrimination against women in 1995, whereby the general recommendation number 19 elaborate on the link between the discrimination based on the violence. Therefore, actually, our Domestic Violence Act 1994 come to protect the domestic violence of the married women or men, and even though the children, including defector wife and husband, former spouse, children below age 18, and those who have mentioned earlier just now. So the reason why this Women's Act Organization reports, WAOs, also, and the previous researcher actually they found out the domestic violence actually does not recognize the domestic violence to a woman as per crime per se. So this is what in this authors, his views. So when we read the Domestic Violence Act, bear in mind that all the provisions in the penal code which is relating to the offences affecting the human bodies, such as criminal assault and force, wrongful restraints and wrongful confinements, kidnapping, abductions, causing hurt or causing grievous hurt, and etc. It could be relevant because if you take notes, if we take notes, domestic violence, when we read the domestic violence, in fact, it will say it has to be read together with the penal code. So if let's say these actions, or we call there's an assault or battery, or this which has involved of these criminal elements, so the penal code will be relevant. So now, nevertheless, they say majority of these domestic violence cases in Malaysia actually fall under the sections 323 of the Penal Code for voluntary causing hurt. Okay, so this could be relevant. Now, then we go to this mediating family dispute involving violence in Malaysia. Now, when we talk about the mediation, yes, under the mediation, of course, for us to use the mediations to resolve the dispute, of course, in the family dispute, yes, it could be relevant, such as if let's say there is a distribution of the property, there is an issue of the distribution of property. If let's say there is an issue of child custodies, then mediation could be relevant. However, when it involves these criminal elements, of this domestic violence. So it could be become a gray areas to my personal view, because under our Mediation Act 2012, it in fact actually say mediation is not suitable. One of the, they have a categories in which they indicate the mediation is not relevant or is not applicable to these matters. So one of the matter is criminal offense. Okay, criminal offense. So if let's say this domestic violence involve the criminal violence, so and which include link to the penal code. So by right, I would like say mediation may not be suitable, may not be suitable. But anyway, we look at this mediations family dispute involving the violence in Malaysia. So they say domestic violence often is a hidden and difficult to prove, right? So, so as we know, if we want to convict someone to be offense, we need to prove it. But as a general law, domestic violence is quite difficult to prove because not many report. The victim would like to come forward and report it, okay, or become the witness, okay. So they say victim might be fear to the batterer or anxious about the safeties, which ultimately not to report the violence to the police. So this is the main reason it's difficult to prove. They say eventually the victims agree to mediate the process which contribute the balance in power imbalance issue in the mediation process. So even those they may say, okay, I would like to mediate, but it's only relevant to the certain issues like they may say, I hope that my husband won't stop the drinking. Okay, so because drinking could lead to the violence in due course. So if we look at the Islamic perspective, because Islamic perspective, this SULO programs, which is quite similar to our mediations. Of course, although it's not a direct translation, but they have a similar characteristics between SULO and mediations. So in the court, Sharia court, they say they have no legal provision for the balance in power imbalance and the exemption for the issues of violence. This author, Daphna, asserted in her article that normally most of the divorce cases they involve for these violence cases in which the batterers are more successful than the victims. For instance, securing the children. Unfortunately, when the custody of the children is being given to the batterers, the children may have exposed to this violence as well. Okay, so other than that, of course, as we know, one of the elements in this case, because if let's say, we suggest that domestic violence to be brought to the mediation process, then there could be a first issue we need to take note of. There could be a power imbalance. Okay. So second thing is the mediator could be quite difficult to commit her neutralities, because as we know, in the mediation process, the mediator is not, it must be neutral, okay? And of course, he will not make any suggestions because the solutions and the settlements terms must be come from the parties. So if let's say there is a balance, power imbalance between the parties, so the question that we have to take note is whether it will reach the fair agreements at the end of discussions or not. So that is the things that it may cause the injustice to the victim in this case. So of course, at the end, this mediation process could be very difficult and stressful. So according to this, some of the authors, for example, Rossi, he said many benefits of mediation may apply to the disputing party who have a history of the violence if mediation is being used to resolve the disputes. And this Jessica authors, he said, although it has been never considered appropriate to mediate violence, mediation supporters contended that sometimes mediation in this kind of situation may use as a victim communicate safely with the betterer about the stopping the violence and help the betterer and the victims explore the treatment options and help a family arrive at the visitation arrangements that control the abusers. So, of course, some of the authors, they feel if, let's say, they really want to use the mediations in settling this domestic violence, it could be limited to this, like to tell the betterers, saying that, okay, could you kindly stop the violence and to treat this victim nicely or whatever. Now, of course, in the presence of this mediator, it could be said, yes, I agree to do so, but who knows at the end? At the end, when they go back to the home, whether they will repeat the same offense or not. Now, this could be something which is quite difficult for us to control. Okay, now, then according to this Dow and Elizabeth, they conduct the research on these mediations in the marital dispute in Malaysia by analyzing the real case study of the divorce, including this domestic violence. Because one of the reasons that the couples will go for divorce is because of this domestic violence. So they say, based on their studies, it was found that the mediator could not be recognized the presence of the domestic violence if, let's say, there is no physical violence appear on the victim. Because bear in mind, domestic violence not necessarily happens to the physical violence. It could be emotionally and mentally violence as well. They say, unless the mediator is trained to recognize and understand the natures and the effect of the family violence, then maybe the violence may be identified. Because sometimes when they mediate the family mediations, so throughout the section, the mediator found out it could be the violence could be happens between these couples. So the issue now comes to the mediator is whether he should report it or not. Okay, whether he should report to the authority or not. Bear in mind, because all the discussion during the mediation must be private and confidential. Okay, so the mediator cannot leak the information without the parties' consent. Now, if we look at the overseas situations, especially in Australia, I take Australia as an example. In the Family Law Reform Act 1995, actually it has been compulsory for the mediator to screen separately the family violence to ensure the safety of the weaker parties. So it can be seen that Australia used a safer modes in which to shelter the mediations, because in this act, actually they put in the provisions of the mediations. Now, however, if let's say we come back to our Malaysia, our current practice of mediation in family dispute will not accept any cases if let's say there is violence, because currently our family mediation will still focus on more on the like children custodies, like the maintenance, property distributions. Okay, then okay, if let's say in this Australia, because based on some of the studies, they found that if let's say because one of the requirements here, they said they need to screen separately of the parties. So how the mediator works here. Now, before the mediation process, they have to do an initial phone calls. So, of course, they have to check with the parties, what are the concerns, whether they have any advocates to represent them in this mediation process or not. Now, in the pre-mediation intake or orientations, they have a separate meeting with both parties. It is suggested to be face-to-face. Now, of course, due to the COVID, the current situations, any meeting between the party could be conducted via the online because we have e-mediations. But however, it could be suggested that face-to-face could be better because we can see the expressions, the face expression of the party. Sometimes they just close one eye, sometimes they just do something like the face. You can see from the face that whether they indicate any hints to you or not. Okay, then they have some of the different dates or whatever, because this could be have to reach mutually. So both parties it must be available on the same date and time. Then they have when you ask, you use the open questions. Okay, so making a decision about whether or not to mediate or not, because of course after they screening the process, then the mediators have to ask themselves whether I should proceed or not, because some of the factors that they need to take into consideration, i.e. the parties is in the immediate dangers, and not appearance immediate dangers, but also abuse the party, disclose the violence, and if let's say there is no violence but there is abusive or controlling someone, or whether there is any protections orders or not. Okay, in Malaysia, actually, our domestic violence provide this protection order, interim protection orders. Okay, so safety planning screening is ongoing process. So this is some of the issues that the mediators, I mean, in the Australian, they will take notes. What feels safe to a person in mediations, whether there are any signals between the clients and in mediation. In the event client seems indicate of the violence, and identify who should to call or who should go for us for help. Okay, for example, any safety plans. Okay, now of course, one of the things that we need to take note is in mediation will very emphasize on the confidentialities. So if let's say, of course, mediators could only be allowed to review all the discussions upon the consent. Otherwise, he will breach of these confidentiality rules as well. Now, so getting ready to mediate or not. So, so of course, often the mediator will be informed. This is domestic violence. Then of course there were ways. But of course sometimes the mediators will stubborn into them. Now, if let's say mediator go for these violent cases, they will stress that mediator's requirement is to hear and affirm self-determinations on the agreements. That means mediator will not suggest any solutions for them. So of course, if let's say there is necessary to stop the discussion or stop the process, mediator has a right to do so. Okay, then they have to break the parties into the caucus sections if they feel that there is something when necessary. So caucus sections, they can use a separate rooms to allow the party to speak freely. And of course, if let's say aggressive party refuse to allow the caucus, then they have to be the guardians. Okay, or even though mediator feels that they are not able to proceed, then he has a right to terminate this process at any time. Now, in Malaysia, of course, we have some other acts which is relevant to the mediation services. For example, in our Jabatan Pangkuan Tuaman, we have this in the third schedules of the Legal Acts, Legal 1971, applicable to the mediation service. Now, our focus will be on para B. They say all civil family cases they will accept. That means family disputes, but they say accept cases involving domestic violence. That means if let's say you are referring to the legal aid service, which you require the mediation process. So if let's say the cases involve domestic violence, they don't accept. So under the Mediation Act 2012, so in fact, I would say it could be silent whether mediation is suitable for domestic violence or not. But if let's say, of course, in the list, they will say certain cases or certain situations is not suitable for mediations. So they didn't say domestic violence directly, but if we try to link it back, as I said earlier, Domestic Violence Act will be read together with the Penal Code. So if let's say there is a criminal offences such as causes injuries or to any parties, to any bodies of the parties, it could be fall under criminal offence. So if let's say criminal offence, then it will involve a penal code. So therefore mediation is not relevant. So that is the current situation in Malaysia. So they say most of the previous researchers, they agree that not all types of cases in family dispute are suitable to be mediated, especially when there is a personal danger. So Jessica and Swaida, these two researchers, they highlighted and categorized on the cases that relate to the personal dangers as one of the criteria of the cases in family dispute that are not appropriate to be mediated. Okay, then subsequently, there are a few researchers as well. For example, Sherry, Clark, and Davids and Daphne, they also in the opinions that mediation are not an appropriate way to resolve the family disputes involving the violence. But of course, if let's say there is no criminal elements, I would rather say yes, it will be still relevant, like child custodies, okay, like maintenance issues. So they say apparently the main examples of the cases in the family dispute that are inappropriate to be mediated according to a certain criteria that have been categorized in any cases involving domestic violence. So that could be that could be the ends of my sharing sections. So okay, so now I open the floor for the discussions and the Q&As.
Okay, sir.
Thank you very much.
Yeah, thank you very much, Mr. Wong. That was a very illuminating presentation. I believe all of us here have obtained quite an input regarding the matter at the hand. In a nutshell, it is silent for mediation to resolve the dispute of domestic violence because if the violence, including the criminal violence or any injuries, it shall be addressed according to penal code. So however, the mediation process may be useful for the victims as a way to communicate with the abuser in a safe zone. How a mediator will not suggest a solution, but they will assist the victims to affirm their self-determination.
Correct.
Now, moving on to the question and answer session, my colleagues here have a few questions that they would like to address to our speaker tonight. Perhaps Ms. Siti Nur Aimi would like to start first, followed by Ms. Atira and then Ms. Taranisa.
Sure.
All right, thank you, Ms. Emma, and very good evening, Mr. Wong. I am Siti Nur Aimi, and there are a few questions that I would like to ask you about the topic tonight. So my first question is, in the event where the victim of domestic violence insisted to save the relationship by way of ADR, aside from mediation, would it be possible? And if it is possible, what other methods of ADR can be utilized for cases of domestic violence?
Okay, in fact, this is a very interesting question. Now, first, we'll go through the types of ADR first. ADR, of course, mediation just one of the types of the ADRs. So Then your question is whether the victim of this domestic violence, if let's say they insisted to save the relation by way of ADR, aside from the mediations, whether it's possible. As I say, we will look into this. If let's say it involves for this penal code or criminal offences, because domestic violence it shall be read together with the penal code and other relevant laws, which involve the criminal element. So I would rather say if let's say they involve a criminal element, so mediation may not be suitable, may not be suitable because it causes like bodily harm to the parties. But however, it does not mean that ADR cannot be applied. So because if we look at the initial sharings, we say ADR could include mediations, arbitrations, conciliations, adjudications, and these methods. So I would rather say we still can apply ADRs, but we will consider to use conciliations. Now, conciliation, because in the Domestic Violence Act 1994, in fact, Section 11 has also explained about this counseling. So counseling about the matrimonial disputes. Now, of course, conciliations, it will involve for the third party as well. Parties as well. But of course, the difference between this conciliation or conciliators, okay, they're allowed to give like suggestions to the parties, or I mean, in layman terms, it could be similar to these counselors or counselings. So that could be the one because they will use the third parties, assist by the third party to resolve the dispute between the two parties, A and B. So I would rather say instead of using mediation, maybe we can advise them to use the conciliations, okay? Because mediations, if we use mediators, now we have to know the purpose, why they want to use a mediation. Because there could be a limitations in the mediators because he must be impartial, neutral, and he cannot suggest any solution, right? I believe in the domestic violence, there was solution. So now how? My husband every day keep on beating me. So how? I want solution. So that could be restrain the function of mediators. So that could be, I personally feel that it could be more relevant if we could apply conciliations, because conciliation is one of the method of ADR as well. Okay, thanks.
All right, thank you, Mr. Wong. So my next question has in relation with the first question. Since you said that we can go for conciliation for cases of domestic violence, what kind of resolution would be appropriate for a conciliator to give to the parties?
Okay. As I said earlier, if the relevant method, it could be conciliations, which kind of resolution, I mean, we can go through counseling. Counseling, I mean, is one of the quite sufficient methods to resolve the dispute because at least we know what the parties' feelings. Okay, let's say, for example, wife keep on complaining, saying the husband every day beating her. So we had to ask husband, why? Is it your natural characters that you like to beat people? Or is it just because I was affected by the stress or there's a from my works or others? So if let's say we know the root cause of this domestic violence, then we will go find the solution. I believe that could be the way that we can get the solutions. But of course, some of the, based on my experience, some of the domestic violence, it could be affected by some of the medications, medication, especially if let's say, for example, the husband, he likes to drink and until become drunk. hit. Okay, so of course he's lost control. So they will use, or maybe the wife, the husband, sometimes husband will complain, say that because my wife everything keep on nagging, so I cannot they will say I cannot tahan anymore, so I want to release my anger and tensions. So that could be the root cause. So I think counseling, it could be one of the solutions under the conciliations. And even though if we look at this domestic violence act, so in order for the parties to get the protection orders, so they have to go through the counseling as well. So I mean, in fact, most of the family matters, family dispute matters, you want to get any order or restrictions or something restraint orders, it will suggest that they have to go through the counseling, including if let's say they want to divorce, they have to go through counseling. So I think that could be one of the solutions. Okay.
All right, thank you, Mr. Wong. I have one last question for you. Have you ever received accounts of domestic violence from victims requesting for ADR, especially mediation? And how do you handle this situation, considering the current law of mediation does not accept cases of domestic violence?
Okay. So far, based on my experience, no, because there is no victim requesting the ADRs. Based on the time now, of course, to what I know, in our society, the awareness of these ADRs could be quite low. I mean, maybe it could be improved. It could be it will improve from, if let's say based on the last few years, or even though earlier songs, when I say any dispute matter, they will just say, oh, I go to the court to resolve it. They say, but when you say ADR, they may ask what is ADR. But of course, nowadays, I think the awareness of the public towards this ADR is increasing. But anyway, so far, for the victim for this domestic violence, so far they never asked for the ADR as one of the mechanisms to resolve the mediation. But anyway, if let's say in order for the parties to get any protection order or interim protection orders, they have to refer the matter to conciliatory bodies. So it's some sort like, actually, we go back to the earliest one, I said conciliations. That's what they have a special bodies to ask the party to come. So come, we have a talk, we have a section to find out what could be the reasons. Is it possible that every day you must not only physical violence, but it could be emotionally and or mentally abuse as well. So I think how do I handle the current situation relating, if let's say they don't accept. So if they don't accept mediation, I mean, another way we can go for is conciliations. Okay.
All right. Thank you, Mr. Wong. That is all from me. Thank you very much.
Okay, welcome.
Good evening, Mr. Wong. My name is Adira. I would like to ask a few questions. My first question would be, is it possible for Malaysia to incorporate the process of mediation to handle cases of family disputes that involve violence, such as in Australia? And if we do incorporate Australia's approach to mediate such cases, is there any additional process to be added to make the approach more effective in Malaysia?
Now, actually, this is a very interesting question, right? Because now we're talking about our current law in Malaysia. Now, whether it's possible or not for us to incorporate these mediations in these domestic violence cases, right? So, I would say yes, it could be possible. It could be possible, but of course, first, before we say yes, we need to amend the current law first because our current law did not actually, they don't really provide the straight, clear answer, say yes or no. So as I said earlier, mediation is not suitable for criminal cases. Now, then when we go back to domestic violence actions, if let's say it involve the criminal elements, then it will refer to penal code. So therefore, if let's say in such situations, then mediation may not be relevant or may not be applicable. But however, if let's say we really want to incorporate mediation in this domestic violence, which involve the criminal elements, we need to consider the role of the mediators, because mediator is to facilitate the parties, facilitators, and he is not a problem of decision makers here. So if let's say we apply mediation in this domestic violence case, then the husband will say, so now what is the solution? Wife will ask, so now what is the solution? So the mediator could be in dilemmas, right? So I would say, yes, it may be relevant in a certain questions, like mediator can ask the party to join, to come together, to express their view. Okay, why this party A is keep on every day keep on beating party B's, or why every day party B's keep on doing this emotional abuse or violence to party A's. So that could be the ways. But in terms of come out with the solutions, I think it's quite hard for the mediators to do so. But anyway, if let's say really we want to implement this mediation in the domestic violence case, I think our legislator they can do something else, but in the appropriate ways, because it's not easy that we want to incorporate, because a lot of issues that we need to take into considerations. Okay.
All right, thank you, Mr. Wong. This is my last question. What should be done if the abuser and the victim do not cooperate in the mediation session or any other ADR session, such as conciliation?
Okay. Now, assuming if let's say we apply mediation in this between abuser and the victims, so in the openings, before the opening statements, even though the mediators will set the ground rules, right? Mediator will say, okay, in the mediation process, the party cannot use the abusive words towards the parties, right? Or even though, let's say, they say, when one party is talking, another party please remain silent. Okay, so this is some of the ground rules. But of course, mediation has his own authority as well. So mediator has to remind the parties that if, let's say, in the events, the party does not cooperate, okay, not cooperate, so the mediator has a right to end the sections at any time. So that could be the ones that if, let's say, they are not cooperating. That's why before the mediation sections, the mediator should ask the parties to give the full cooperation. So if, let's say, suddenly they don't give, then the mediator will remind them, okay, you see, Mr. A, in the beginnings, you have promised to me that you will give full cooperation. But now you see what you did. You have to interrupt the parties or disturb another party, etc. Right? So if, let's say, you don't follow the ground rules that we have agreed earlier, so then the mediator can say, I will end the sections, end the sections. So, but of course, this is at the discretion of the mediators, but try, unless it's necessary. Otherwise, normally the mediators, we don't end the sections. We don't simply end the sections because it involves a lot of cost, the time consuming, the effort, the energy of the parties as well. Okay.
Thank you, Mr. Wong. That will be awesome.
Good evening, Mr. Wong. My name is
Evening.
Tarini. I have few questions on our topic today. So my first question is, in your honest opinion, is mediation the best method to solve family disputes, especially domestic violence?
Okay. In order to answer your question, yes, it could be interesting that you ask whether it's the best option or best methods. I would rather say it could be one of the method, but it may not be the best. It could be one of the option. We say one of the options because as we know, these were involved for the how to say, especially the domestic violence cases. The party are very emotional. Party are very emotional. So as a mediator, of course, during the mediation process, we need to control, we need to take care of the party's emotion as well. So actually it's multi-functions, multi-function. But bear in mind, if let's say when the parties, they are in like very emotional, as a mediator, we only can acknowledge their concern. We say, yes, Mr. A or Miss A, I do understand your situations. But you cannot say, oh, why don't you do like this? Then that could be the, limitations, limitations to the mediator. So I would rather say in certain situation, maybe they can use, but it may not be the best methods. So I would rather say it will be not a vice versa. But of course, if let's say they want to use the ADR mechanisms, they may consider conciliations. Okay. Right.
Okay, thank you, Mr. Wong. My next question is, what are the factors that contribute to a failed mediation in solving family disputes?
Okay. So, I mean, not only family disputes, actually in terms of any mediation, regardless of what subject matters, there could be a failure. Not every time when the mediator conduct the mediation process, it will reach the settlement agreements. Not really. So it could be mediation process which fail. I mean, as a mediator, we get used to it. We don't feel upset that, oh, I cannot resolve this dispute, or because we don't have a mindset at the beginning, always say that, oh, whatever cases that I handle, it must reach the settlement agreement. So not really, because as a mediator, always we know that in order for the parties to reach the settlement agreement, the solution must come from the parties. Mediator just to facilitate, to combine together, not to suggest. That's right. So the main factors, I would say that, of course, there are many factors, but the main factors that contribute to the mediation fails, especially like in solving the family dispute, is the parties, they don't render the 100% commitment and cooperation. Because initially they will say, okay, I want this, I want this. If you don't give me this, for example, family disputes, for example, I take the child custody, because child custody always become an issue. For example, they have only one kid. Okay, the couple only have one kid. The husband said, I want the kid. The wife also said, I want the kid. So how? Then the husband will blame the wife. You are not responsible wife. You cannot take care. You don't have financial support, etc. Then the wife will blame the husband. You have a bad characters, etc. You do not have time to take care of the children, etc. So you see, so if let's say they don't cooperate, so I mean at the end it will fail. So if let's say just now, as I say, we always encounter that the party at the beginning, they will blame each other. They will blame each other. So I mean, if let's say they keep on blaming, so in the mediation process, we call this as a deadlock. That means we are not able to proceed. So because they keep on arguing, both parties, they don't want to cooperate. So then that is a suitable time for the mediators to use the caucus sections, caucus section, because, or we call it private sections, to ask the party, okay, you keep on saying that the husband, the bad thing about the husband, may I know? Or maybe you ask the husband, because in private sections, you can ask anything. There's no limit because nobody, but of course we subject to confidential rules. Okay, but when you ask the disputant, the party, you directly say, okay, just now your wife say like this. Can you tell me about this background? Then we ask the party to tell us. We only guide them, but of course we don't use our facts because mediator, when parties say anything, we have to jot down. So we say, according to your wife, she said like this. So could you kindly explain something or tell me more about this? Then in the private section, then they will slowly tell. Then you will notice that, oh, at the end, that is the purpose why they want these children. So that's why. So then we can brainstorm. We call brainstorm the parties. Brainstorming. Then we can ask the another questions to the party is, for example, is what if your wife insists want to take the kids? What could be your worst scenario you can take? Okay, then we can apply this one. We call partner and whatnot, like the best alternative to this resolution and the worst scenario. So of course the best one is the, both parties will be happy because they get the best solution what they want. But if let's say worst scenario, the wife insists doesn't want to give the custody to the husband, and then of course at the same time the wife, we can ask, if let's say the husband insists want the custody of the children, what could be your do? So that is the one that, the function of the caucus sections or private sections to let the party to tell the feeling. So because that is the one that incooperative, right? If let's say party they don't cooperate, so it's very difficult for the mediator to go on or to proceed further of this mediation process. Okay.
Okay, Mr. Wong, thank you. And my third question is, other than domestic violence cases, what are other family disputes that can be solved by way of mediation?
Okay. It's a good question. So I think, for example, like family dispute, we have of course, marriage because one is whether they want to divorce or not. That could be suitable. Another one, if let's say they confirm want to divorce already, they cannot save the marriage, that one is fine, but they will involve like custody of the child. Okay, just now I use an example of property distribution. Let's say we have one house. So how do we, matrimonial house, how do we solve it? Okay, and then sometimes the family business, the brothers, sisters, the father passed away, the parent passed away, left out the business, family business. So brother claims that the sister is not competent. Then the younger brother will blame the elder brother that he is not competent. So who is the suitable candidate to become the director of the company? So that could be the family dispute or the family business as well. Then regarding, especially for the marriage matters, another one could be the maintenance fees. Husband said, I only afford to give you 500 per month. But the wife said, no, I want 1,000 per month. So that could be the dispute that actually, if let's say for this situation, we can use mediations. Okay.
Okay, Mr. Wong. This is my final question. What usually are the solutions that can be achieved through mediation in solving domestic violence disputes?
Okay, I think if let's say we can use the mediation, for example, there is no involved the criminal elements, so the parties will know and aware why these abusers he did what he did to the victims. Actually, why? So first we need to know. So if let's say throughout this mediation, at least we know the cause, right? The root cause of this family violence. And of course, at the end, to let the abusers to give an promise, or we call undertakings or agreements, that he will not do the same things to the wife. So maybe they will say, okay, if let's say you still beat your wife, so the wife will not hesitate to file in the petition to ask for divorce. So that could be the something that they can achieve. But anyway, I mean, as I say, mediation may not be suitable for domestic violence which involve a criminal offense, because most of the time, domestic violence, it will involve for the criminal elements. Yes. Okay.
Okay, Mr. Wong, thank you for your explanation.
Welcome.
Thank you all for the engaging question and answer session. I believe we are able to understand a lot more about mediation and alternative dispute resolution as a whole, having regard to domestic violence. Before we end the event tonight, on behalf of my group mates and I would like to express my gratitude to Mr. Wong Hua Siong for his presence here and for illuminating us on the issue at hand. I believe all of us here, well as the public watching this recording, would benefit from his input tonight. To mark our official end of tonight's event, I would like to comment a photography session before we leave the platform. My colleague Atira will assist us on this.
All right, ready? 1, 2, 3. 1, 2, 3. Okay, one more freestyle.
Freestyle.
1, 2, 3. All right. Thank you.
Okay, thank you very much. I hope that everyone will benefit from this sharing sections. But if there's any shortage, welcome most of the comments. Okay.
Thank you everyone for tonight. To those who are watching the recorded session, thank you so much for your time. We hope you gain much knowledge on the topic. We appreciate it if you can fill in our feedback form that will attach together with the recorded video. That's it. Thank you. Stay safe and take care.
Thank you very much. Okay.